very good evening, ladies and gentlemen, and they and everybody. Welcome aboard. We have, uh, he doesn't actually need an introduction, and I'm actually getting nervous while introducing him, but I'll try my best. We have senior advocate rather, with Mr. Vivek Sood with us, and he's actually going to talk about the topic we all know. Uh, Sir has been a member of Bar for almost 3 decades now, and he's author of almost 7 books. A few of them is the latest one is Chaff and Green. The few of his previous writings include Progress of Indian Economy, Right to Privacy, Emergence of Commercial Justice, Cyber Law Simplified, Fundamental Right to Internet. And I urge you all to uh, pick up one of the books from the shelf and do read because his writing style is very simple. He basically connects with his audience. That's the best part of his books. There's not too much of technical jargon and which goes over your head. So they're nice books to read. That's my personal recommendation. And Sir is a lovely human being who definitely gives a lot of time to a member at the bar. You can always approach him, ask questions. He's always there to help you. One more thing, sir is a presidential candidate for next Delhi High Court Bar Association elections, and I personally feel that that's a great decision sir has taken, and we should all, along with our colleagues, whosoever we know, member of Bar Association, other bars, to please support sir in his venture to become a president in the next term. And I am personally there for sir. So not, I won't go further. I leave the floor to the sir. And before that, I also introduce Raghav. Raghav, of course, is the editor-in-chief of Lawyers Club India, the portal you're all on. How the session is going to go, sir is going to talk about the topic of bails in mostly white-collar crimes, uh, followed by session of questions and answers. We're going to leave an open mic so that you can directly address your question to sir. We appreciate some good questions coming from your side, and that's how it's going to be. Uh, Over to you, sir. Thank you.
Before we start, sir, very sorry to interrupt. Guys, please use the chat box for the questions because we all have mics. सब लोग माइक एक साथ यूज करते हैं तो किसी का क्वेश्चन पहुंच नहीं पाता है and that becomes a disturbance. So you are all requested to please follow how we do it on LCI. Raise your hand. There's a feature on Zoom. आप hand raise कर देंगे. The team will see and you will be given the chance to ask your question. If you want to put it on chat, put it in chat. First come first. I'll read from there and put the questions to sir. The floor is yours, sir. Thank you so much.
I think we can start the session, and I think you can ask me a question. Shikhar, will you be anchoring the?
Sir, Raghav will be anchoring the question answer round. I will be assisting him.
Very well, very well, very well, very well. So thanks for bringing me on this platform, and so we can get going.
Right, sir. Let's start. I'll put the questions one by one. We have a couple of questions. So we start with the basic concept, sir. जो हम बहुत बार सुनते हैं, bail and not jail. And how has this come into being and what has been the judicial approach? How have the lawyers been, putting up around it and all that? And after the basic perspective is set, we'll go on to the other questions.
Okay. So, we've all heard of this concept, bail, not jail. Or bail is the rule, jail is an exception. But let me explain this concept differently. Why this concept of bail, not jail? And jail, not bail? Why not jail, not bail? Why bail, not jail? Now, first of all, the most fundamental principle of criminal jurisprudence or criminal law is proof beyond reasonable doubt, which means the prosecution must prove beyond reasonable doubt that the accused has committed the crime. Now, this concept has also been explained through the Blackstonian principle, according to which 10 innocent men or 10 criminals may go scot-free, but one innocent should not be incarcerated or punished for a crime. Another way of explaining these principles is presumption of innocence, which means every accused is presumed to be innocent until proven guilty. Now, when you analyze these principles, what emerges is this. It is very, very onerous as an onus on the prosecution to prove that the accused has committed the crime. An accused is innocent, an innocent man. Now, when you apply these principles to the law of bail, what emerges is bail, not jail. Which means, since the accused is an innocent man who is yet to be proven guilty after a criminal trial, therefore, release him on bail. Otherwise, it amounts to keeping an innocent man in jail. This is the core of this concept of bail, not jail. Or bail is the rule, jail is an exception. Now, this does not mean that in every case bail has to be granted or bail should be granted. This concept of bail, not jail, or bail is the rule, jail is an exception, has evolved into a set of principles. For instance, the flight risk. If there is an apprehension that if the accused was to be granted bail, he will jump bail, he will abscond. Therefore, in such cases, bail should not be granted and the man should remain in jail during the trial. Or if there is an apprehension that he may influence witnesses, he may tamper with the evidence, he may threaten witnesses, or he may try to influence witnesses, then also we apply the exception, jail, not bail. So these are some of the principles that have evolved over a period of time. They have been crystallized into this concept of bail, not jail. This is my understanding of this wonderful concept of bail, not jail. In 3 words, the entire law is encapsulated. That's the beauty of this principle. But behind this principle, I have explained the jurisprudential aspects behind this concept of bail, not jail.
Beautiful, sir. Sir, the second part of the question, what is the judicial approach right now? In the practice, are we really following this position of law that is written, in the jurisprudential perspective? How is it in the courts?
I do feel, after 30 years at the bar, I do feel bail should be granted in many more cases than it is in the judicial system. But it's a dilemma. Now let me explain this dilemma. We all know, we all know about justice delayed. We all know about endless criminal trials. Now, if bail was to be very liberally granted in every case. The man will come out and the trial will be endless. So he will not suffer the punishment. This is a dilemma. So therefore, there is a judicial mindset that let's keep him in jail for as long as possible. There is another judicial mindset, there's another dilemma. We all know in India, witnesses turn hostile, or they don't support the prosecution case, or they commit perjury on a platter, they lie on a platter. In fact, the Supreme Court has time and again said that we hardly come across a single witness whose testimony does not contain falsities, exaggerations, embellishments, embroideries. So therefore, this judicial mindset has developed, where the judge feels that, yes, I know this man will go scot-free in a murder case because nobody will testify or the witnesses will turn hostile. So better to keep him in jail for as long as possible. Now, I don't agree with these judicial prejudices, if I may say so. I don't agree with these ideological positions. I'm a man of law. I would want to apply the principles as they are. So therefore, I come back to your question. I do feel that the judiciary in India, insofar as heinous offences are concerned, is rather conservative in the grant of bail. Although in recent times, in the last about 2 years, the Supreme Court has been time and again emphasizing on the concept of bail, not jail. But many of those principles laid down by the Supreme Court do not percolate into the criminal justice system. That's another problem. You have Antil's case, you have so many judgments, but they don't seem to be percolating into the judicial system, the criminal justice system, down to the sessions court or the magistrates court. So there are judicial mindsets which I see. You may call them a mindset, you may call them a prejudice, you may call them a dilemma, you may call them, you may give any expression to it. But definitely, I feel that the judiciary is rather conservative in the grant of bail insofar as heinous offences are concerned. I must give you a practical experience. I am doing this, I am arguing a bail application in a murder case, where out of about 100 witnesses, only 30 witnesses have been examined in about 12 years of criminal trial. And I have been urging, the High Court that please apply. Indrani Mukherjee has been granted bail after about 3 or 4 years. Please apply that principle. But there is a resistance, in heinous offences like murder. There is a judicial resistance in the grant of bail.
Right, sir. Sir, इसी पे 2 questions हैं. One, yes, there is resistance, and heinous offences mein, economic offences mein, it actually becomes a tough case to crack for young lawyers who go to the court and try to convince the sessions court or the lower courts. What do you think, briefly, what should be their approach? How should they approach the judge? What should be their quintessentials when they are trying to crack such cases for bails?
That's a very interesting question. Like heinous offences, murder, rape, kidnapping, ransom, even economic offences have been made into a separate category by the judiciary. You have so many judgments where it is said that economic offences is like cancer, it is like genocide. There are multiple victims. they eat into the economy, they eat into the society. So therefore, they should be dealt with a heavy hand. Bail should not come easy in economic offences. You know, there is again a dilemma. Now, I do feel I am in favor of the principles laid down in Sanjay Chandra's case. You know, Sanjay Chandra is very often quoted by all of us defense lawyers in different courts. Now, in Sanjay Chandra, the 2G spectrum scam, the scam was, it was said to be, worth thousands of crores. And all the accused men, they spent about 6 months, 8 months, 9 months to about over 1 year in jail before they were granted bail by the Supreme Court. Now, not many people know about these background facts, these subtleties behind Sanjay Chandra. Now, let me tell you, while the case was considered to be so serious, the CAG report and the report said that the scam, the 2G spectrum scam was worth over 1 lakh crores, over this and that. Eventually, all the accused were acquitted by the court. So what do you do? What do you do? If you keep people indefinitely in jail and ultimately they are acquitted by the court, and the acquittal was an honorable acquittal, not benefit of doubt. The learned judge has said that the prosecution miserably failed to prove its case. What do you do? When you keep people in jail indefinitely without bail, and ultimately the cases end in an acquittal, what happens? How do you redress? How do you return back those months or years spent in jail? Now, this is one side of the coin. Now, let me show you the other side of the coin, the dilemma. You have these cases against builders, multi-victim scams, multiple victims of cheating. And, suppose bail is granted. Suppose we apply the principle of bail, not jail, liberally. What happens? The cases go on endlessly. The trial can never end. Now, I'll just give you an example. I've been appearing for the, Consumers Welfare Association or the home buyers in the Vigneshwara case. Where the Dhaiya family, Sunil Dhaiya and his brother, they have been languishing in jail for about almost 7 years without bail. Now, let me tell you, even after 7 years of the filing of the charge sheet, even charges have not been framed. And the case documents are so voluminous. You have these trunks of documents coming in. You have hundreds and thousands of witnesses. You have thousands and thousands of documents. Now, where in such a case, the moment when the case comes up in the trial court before the Chief Metropolitan Magistrate or the additional Chief Metropolitan Magistrate, there are already 100 cases lined up on a given day. The moment the judge sees trunk full of documents, he puts it on the side. He will give a date on some pretext or the other. The IO is not available. One of the defense counsel is not available. This is not available. That not available. So these cases are endless. So I have advocated in my books earlier that, wherever, and I have in chaff and grain, I have called this phenocide. I have coined the expression phenocide, like genocide. Now, in cases of phenocide, if bail was to be granted liberally, if bail, not jail, was to apply liberally, the cases will not end for the next 100 years. What do? No punishment. It means the man comes out on bail and the case will not take off for the next 100 years. What happens? There's no closure. So I've advocated special courts. We need to expedite the criminal trial. That's the basic problem. We must have special courts for economic offenses, especially in cases of phenocide where there are multiple victims. So, these are dilemmas of criminal justice which I have explored in Chaff and Grain. There's no one answer. Bail not jail in many cases, jail not bail in many cases.
Amazingly put, sir. Also, sir, before moving on to the next question, I should acknowledge the kind of energy that you're bringing, the body language that you have. I think hum sabki mila ke itni nahi hogi. I request everybody to please reciprocate it. Please come on cameras. Please show that you're nodding and listening, and you're listening to each and every word that sir is saying. Ye Indrani and the Sanjay Chandra case and Antil's case, whatever sir is saying, these are meant to be noted. Please keep these in your treasures. You use it when you can. Moving on to the next question, sir. Aapne Until case ki baat kari. So there's another question which is, what is your position on whether we should have a separate bail legislation as has been, pioneered by many courts and jurists and even the Honorable Apex Court, and also in the light of the cases that you have just quoted. So what is your position there?
I have addressed this issue in Chaff and Grain, but I will just throw light on this very significant question. In Antil's case, the Supreme Court has said, like in the UK and some states in US, we need a separate bail legislation. I differ with that view, and I'll tell you why. You cannot formulate bail principles in some kind of fossilized equations. First of all, there are myriad types of criminal cases. You cannot classify them. You cannot say, in these offenses, no bail for 4 years or bail after 3 years. It'll be very difficult to classify. It'll be humanly impossible to classify offenses. Secondly, within the offenses, suppose you are able to classify. Suppose you say, in offenses where the imprisonment is up to life, no bail for 3 years or 4 years or 5 years or bail after 5 years. Suppose you are able to do that. Within the offenses, there are myriad types of cases. How do you classify them? Now, let me give you an example. The Supreme Court has time and again said in the last 100 years or so that, these exhortation cases where X stabs Y and Y dies. Now, the family of Y, they will not only accuse X, they will accuse the relatives and friends of X also. They will say, Mr. A, he exhorted X, maro sale ko, maar do jaan se isko aaj. They will say, Mr. B held his legs, Mr. C held his hands. So there is a tendency to rope in so many accused in a case where it was X versus Y. How do you classify them? Because read with section 34 or 120B, common intention, common object, conspiracy, you rope all these accused people as murder accused. How do you classify these cases? So therefore, within the cases also, there are myriad situations. Or let's take the case of rape. One is the Nirbhaya type rape, brutal rape. Then you have cases, promise to marry kind of cases. I have seen landlord-tenant disputes being converted into rape cases. I have seen, in my long career of 3 decades now, I have seen boardroom battles being converted into rape cases. employment disputes being converted into rape cases, POCSO cases. How can law classify? So in my view, bail should be left to the wisdom of the courts. Yes, there will be some inconsistencies. There may be some dilemmas. You may have some conservative judges. You may have some liberal judges. You may have some judges who never grant bail. There may be judges who are better off, who grant bail, who follow this bail, not jail. Many follow jail, not bail. You may have some inconsistencies, but this system, in my view, is better than legislating on bail exclusively. It is impossible, in my view, to legislate or fossilize bail law into a set of principles, set of equations. It's not possible. So I differ with Antil on this account with all my experience behind me.
I would like to interject at this point, sir. You've talked about Satinder Antil, and you've also talked about standard operating procedures that the legislation should not be there. Two examples I would like to cite here. In Allahabad High Court, it is a common practice to file a 482 and asking for directions to the trial court for no coercive steps based on Satinder Antil. It's a very common practice there. It's a Supreme Court judgment where it says that up to category A should be given bail without any problem. Why there is a need for the directions of the High Court when it is so obvious that this is what the apex court has laid down? My second question is, certain High Courts have implicitly or implied made their standard operating procedures. Like, for example, one of the cases, it was a POCSO matter, there was a DNA report. The trial was taking its own course of time. 3.5 years passed. The state has actually submitted the DNA report to be positive. He was given bail. And there were only 3 prosecution witnesses were left. So it's an implied SOP which the court follows. Look, these many years. Same happens with the SOS. You have passed these many years. Merits don't play a role there. But I mean, is it not? They've actually framed their rules and they're actually legislating the entire governance of state based on their rules. What's your take on this?
See, I will answer this very briefly. See, there are elements of subjectivity. There are different high courts doing different things. For example, I must tell you, there are certain high courts where the first listing of a bail application is after 1 year. No listing for 6 months, 9 months, 1 year. So you can improvise the system. What you are saying, the situations you have given, you can improvise. You can add to the principles. You can, you can ensure that the principles of bail are percolating into the criminal justice system. For example, in violation of Arnesh Kumar guidelines on arrest, some police officers have been sent to jail. Some magistrates have been sent to the judicial academy. So there are problems. There are these SOPs, there are aberrations, there are problems in the system. Let's try and improvise the situations. But all said and done, in my view, it should remain within the judicial domain. Bail should remain within judicial domain. Judges are best suited to decide upon bail applications one way or the other. Of course, you need some reforms. For example, I strongly believe that there should be an intra-court appeal against the denial of bail by the High Court. Why? Not many people can approach the Supreme Court. So you need reforms. So these problems are there. You need to address those problems. But it doesn't mean that the legislators enter bail justice.
Shikhar sir, may I continue? All right. Right, sir. So, sir, हमने इसको condense किया. The answer condensed was that let's leave it to the combined intelligence and the prudence of the judges and also the advocates or the officers of the court helping the judge to decide. उसके बाद हम इस चीज पे आए कि कुछ improvise करना जरूरी है. Now on that question, can we go further and can you from your experience tell us कि अब जो हमारे पास लॉ है, the law that we have in the CRPC regarding bails 436 से 450, उसके अंदर what are the different things, just like intra court appeal जैसे आपने कहा, उसी तरह और क्या चीजें हैं जो इसमें improve करी जानी चाहिए?
First of all, I must say that we need to improve the criminal justice system at the bottom of the pyramid. Magistrates and sessions judges have to be sensitized. They have to be sensitized about Article 21. And they have to be made accountable also. That's one major reform that can change a lot of things for the better. Because when an accused is arrested, the first time he is brought before the magistrate. First of all, every magistrate must decide upon the legality of the arrest. Now what happens is, the moment he is arrested, the legality of the arrest becomes secondary. The whole focus shifts on bail. And if the lowest rung of the judiciary, the district level judiciary, is sensitized about bail, and they are made accountable, police officers are made accountable when they file status reports, prosecutors are made accountable when they file replies to bail applications, and the judiciary at the district level must be made accountable. I sometimes do feel that there is a colonial mindset, even in the judiciary. What to talk of the police? And then intra-court appeal, that should be there. Then, when the rosters are made, the rosters should be made appropriately. And then there has to be something called a judicial audit. Why isn't there an audit? You suppose a bail is denied. Okay, you challenge the matter in a higher forum and you get bail. This should not be the end of it. The higher forums must question the denial of bail by the courts below in appropriate cases. I'm not saying that judges should be made liable. I've not used the word liability. I'm using the word accountability. In certain cases, I have come across cases which called for bail on the face of it, but the learned judges denied that grant of bail. You got bail from the higher forum, but where is the audit? How will the system below improvise itself? Only when you have an audit. By audit means there has to be something more than mere writing of the annual confidential reports of judges of the district level judiciary. Audit means, why didn't you grant bail in such a case, in such a blatant case? Or why did you take so much of time? Why was there non-application of mind? Why was there perversity in the approach? So that audit is important, so that we improve the system for the future. These are some of the reforms that I can immediately think about.
Amazing, sir.
As far as bail justice is concerned, again, there are dilemmas. There are dilemmas. It's like a seesaw. Bail not jail, jail not bail. But there is a category of cases. There is a big category of cases where it is easy to decide whether to grant bail or not to grant bail.
Right, sir. So the drill down is police to be held accountable, intra bails and judicial audits. Sir, इसमें से police to be held accountable is a very interesting topic. इस पे अगर कोई anecdote हो जो आप अपने experience से share कर सके, उसके बाद हम next question पे चलते हैं.
I really can't think of an anecdote because I am totally a man of law. But definitely, let me explain this.
Right, sir.
when a man is arrested and he is brought before the magistrate, and the policeman, the investigating officer, the arresting officer, he seeks a PC remand, police remand, and he gives some reasons for PC remand. I find that many times those reasons are flawed, or they are trumped up, or they are false. Now that falsity has to be exposed. First of all, the learned judges should be able to see through that falsity. They should not fall prey to what the prosecutor is saying or what the IO is saying. So the police officers, have to be made more accountable. They have to come out of the colonial mindset, that even the magistracy of the country needs to come out of the colonial mindset, as stated by the Honorable Supreme Court way back in 1992 in Joginder Kumar's case. In Arnesh Kumar 2016, the Supreme Court has said that the police has not come out of their colonial mindset. The judiciary the magistracy has also not come out of the colonial mindset. So these are, this is the best I can put it. I may not be able to give you an anecdote of how police officers function and malfunction.
Right, sir. Sir, moving on to the last question that I have, which is about your book, Chaff and Grain. And I've also taken the liberty to pull out the link from Google of the book from Amazon. I'm putting it in the chat. And this is the last one from my side. And which is कि आप please थोड़ा सा ये बताएं कि इस book में what all do we get to learn, and after that we'll move on to the participants' questions. So guys, you have now is the time you can put your questions in the chat. I have already received a couple of them. I'm waiting for others.
First of all, Chaff and Grain is a very free-flowing book. It is not heavy. It does not have heavy technical jargon. Then I have picked up some interesting topics. Subjects are new. The treatment is different. So first of all, I have started the book with the false cases, how false cases enter the criminal justice system. So I've taken 3 examples, false rape cases. I picked up case studies, real case studies of false rape cases. Then false cases of cheating. Conversion of civil and commercial disputes into cases of cheating. And then the misuse of the SC/ST Act, the Scheduled Caste, Scheduled Tribes Act, how the law is abused by some victims or complainants. Then the second chapter, I have coined the expression malvestigation. Where are the problems? Where are the problems in investigations? I picked up the Arushi murder case. I picked up Jessica Lal, Priyadarshini Mattu, and I picked up some of these highlighted cases that where things are going wrong. And then I've compared those cases with the investigation in Nirbhaya's case. Then I've gone on to, to critically examine the power of arrest in the hands of the police, how it is grossly misused, how it is abused, what are the checks and balances required. Then further I've gone on to discuss bail not jail or jail not bail. Then I have also critiqued the principle of chaff and grain. Chaff and grain is an evidentiary principle evolved for our country. Because the Supreme Court says every witness is a liar in this country. So if you apply the principle applied in the US, if there is any material falsity in a testimony, the whole testimony is liable to be rejected. So if we were to follow the US principle in India, everybody will go scot-free. So we have evolved the principle of chaff and grain, which means the judge will separate the chaff and grain, falsity from the truth. I have critiqued this principle. It is prone to error. It is prone to error. Many innocents may be implicated, may be convicted, right up to the Supreme Court. It's almost a divine function to separate the chaff and grain in many cases. Then I have gone on to, to deal with social media abuse. How should it be defined? How should sedition be defined? What should be the checks and balances to prevent the misuse of these laws? Social media abuse, sedition. Finally, I have examined, fake encounters. I have taken the Hyderabad fake encounters of those 5 or 6 accused of murder and murder come rape of a vet. They were just encountered by the police allegedly, and now they are facing the music. I've compared that case with the Ryan International case that happened, where a small child, he was found killed in a washroom in Ryan International at Gurgaon. Now, the poor bus conductor was implicated and put behind bars for 3 months. Had he been lynched, had he been encountered, what would have happened? An innocent man would have been encountered. So we should not bypass the criminal justice system. So these are some of the interesting topics I picked up. It's an interesting book, and it's very close to my heart. And these are the broad contours of chaff and grain.
Very intriguing, sir. So let me see. We have around 10 questions in the chat box, sir. We'll only take those that fit the time that we have for today. I'll start with Mr. Muazzam. Anybody who has any additional questions, please raise your hands, and also you can shoot those on the chat. Shikhar, sir, you were going to interject?
I was, if I'm allowed 30 seconds, I just wanted Sir to, what he was just talking about. So you just rightly said that most of the witnesses lie in this country, and if we had to import the US system, then it'll be a problem. But do you think is that the reason why perjury is not taken seriously in this country?
Of course. Perjury should be taken more seriously. But if perjury was to be taken seriously, every witness would be in jail. So, it'll be a dilemma. In fact, people should be educated. People should be made conscious and sensitive about their responsibilities as a truthful witness. It's not about, activating the law of perjury only. It's about sensitization. It's about, witness protection also. And we are moving, the apex court and the governments are playing their role. The criminal justice system is not what it was 20 years back or 15 years back. There is some element of, witness protection today, but we have miles to go. And perjury is very, very, very rampant. In fact, I read a beautiful quote, which I've put in chaff and grain, where the Supreme Court has said, the judges have to rely upon God and good luck to arrive at the correct decision in a criminal trial. Because, everybody is committing perjury. All stakeholders are committing perjury. Now, what does the poor judge do? He's in a dilemma. He has to pick up the best lie out of all those lies by all the stakeholders. And then you have chaff and grain. You have all these principles in play. So, it's not an easy job to be a trial judge or a judge in India. It's
But
almost
what
a
is
divine function.
what has gone wrong in our system? So why can't we actually copy paste? What is fundamentally wrong with the system? I'll just add on to something.
I think the credibility of the people when they enter their witness box has to go up, and that will take its own time. It's not a one day's job. Of course, deterrence is definitely one factor. If you have perjury prosecutions, and then the prosecution itself takes 25 years, and then you have another prosecution, for perjury. So, perjury, law perjury, even though it is there, it is in a comatose. Because after the trial will end, then the perjury trial will begin. So it is as, as long as that, as dilatory as that. So we need to expedite the trial. We need to prosecute people for committing perjury. For example, in the UK, people like Jeffrey Archer, the noted authors, they have also gone to jail for committing perjury. Perjury is intolerable in the advanced democracies in the Western world. So we will also, I hope, we will improvise, we will learn, I'm hopeful, I'm very positive about everything. I'm not a pessimist, I'm an optimist.
Right, sir.
Sir,
Raghav, you can continue.
yes, sir. So, sir, इसी के ऊपर एक follow-up आया. Do you think young lawyers should pursue perjury cases on the witnesses after they are done with the case?
Yes. Young lawyers should, they should definitely pursue these cases. But eventually, see, these things are in the hands of the litigant. Whether the complainant or whoever, whether the accused who is found to be falsely implicated through false evidence, whether he wants to prosecute the complainant or not. It's actually in fact, what happens once the accused is acquitted after a Kafkian 20-year trial, he said, let me go home. I don't want to now be a part of the criminal justice system. He takes the lane, he takes the back lane, and he wants to, lead a quiet life after that, rather than dabble in the courts forever. He says, I'm not interested. I don't want to prosecute witnesses. I've had enough. I've suffered enough prosecution and persecution. So the state will have to play that role, The state has to play that role. Judges have to play the role. They must invoke Section 340 more frequently. We have the law. We have the provisions of law. They need to be activated.
Very true, sir. Moving on to the first question from the participant, sir. This is from Mr. Muazzam. And he wants to ask, from FIR, investigation, charges, evidence, at what stage is it best to file a bail application, practically speaking, taking into consideration that our clients, they keep on persuading us to hurry up and get bail for the family members?
No. So that's you can't have a fossilized formula. You can't have an equation. It depends. There are many cases where I say don't be in a hurry. But there are cases where you feel no, it's a fit case for bail. I apply immediately. There are cases where you wait for the charge sheet to be filed. So you can't really make a mathematical formula out of it. Artificial intelligence will not be able to help us, or mathematics will not be able to help us as to what is the stage. It depends upon the facts and circumstances of each particular case. Yeah, the next one.
Right, sir. Sahil, आपका question है, why Sessions Court rarely provide bail? I think sir has already questioned that, answered that. So इससे हम आगे चलेंगे.
I may just add one more dimension to this question. Many Sessions courts and magistrates also fear ostracism. They feel people will say, I was corrupt. I've taken a bribe. So better to deny bail. Go to the High Court. Let the High Court do the grant bail. Passing the buck. They love passing the buck. So this is another dimension of bail denial.
Sir, next question is from Shareen Pathan. She asks, Arnesh Kumar guidelines are not followed by the lower court while granting bail. What is the remedy for the lawyers?
I have addressed this question extensively in Chaff and Grain, but I can see green shoots. The Delhi High Court recently, Justice Waziri, sent a police officer to jail for 1 day for violating Arnesh Kumar guidelines. The Allahabad High Court has sent some police officers to jail for about 2 to 4 weeks for violating Arnesh Kumar guidelines. You need accountability. You need liability. You need to push And one important aspect I want to reiterate, when a man is arrested, the legality of the arrest has to be taken seriously by the criminal justice system. It gets lost in the maze of criminal justice and the focus shifts on bail. Why? The legality of the arrest has to be adjudicated. It has to be taken to its logical end. These are some of the checks and balances that I can think of.
Right, sir. Sir, आपने इतना pump up कर दिया. I think कल सुबह उठ के सब लोग they're gonna put themselves into action. कल कुछ होने वाला है. So next question, Ayushi Mishra, she wants to ask, what is the future in bail jurisprudence when AI enters, and if it enters, will it be a positive change or a negative one? Will it bring uniformity in the ground of bail?
I only hope, AI doesn't go beyond its brief. Otherwise, we all will be dependent on AI, and AI will become the biggest, topmost lawyers. Okay, now let me answer this on a serious note. Because of the element of subjectivity involved in bail jurisprudence, I don't see AI entering the scene. Of course, you may have, some case law. You may have some case law, but to make some scientific equation, I don't think AI will be able to enter, this bail jurisprudence and the criminal justice system. It can act as a facilitator. It can give you data. It can give you case law. It can't decide cases. It can't understand human emotion. Human emotion. Crime is not mens rea, is a state of mind. I'm sure AI can't enter that state of mind to find out what was the mens rea.
Right, sir. Moving on to the next one, sir, very simple one. And Sachin Shukla wants to know your view on whether, is there an influence of the judge in grant of bail, and how does the judicial vices of forum shopping work in real life from the point of view of a lawyer? That is, would you prefer a particular judge to hear a bail or not?
There are some tricks, there are some practices, there are some malpractices, there are some strategies, the timing, when to file the bail application. And, it is lawyers definitely, they do strategize with experience as to who is a liberal judge, who is a conservative judge, when to file the bail application. And insofar as influence is concerned, I will not want to comment on it. I will, only want to say what Justice Gogoi said, that judges also are part of planet Earth. They don't come from Mars or Venus or Jupiter. So, whatever corruption is there in our society, the judges also come from this society. Let's not talk beyond that, But largely, everybody is trying to do his job to the best of his ability. I don't see influence to be rampant. I can't really, I'm not fit enough to really answer this question. I just, argue my brief to the best of my ability. I prepare and argue and come back. I don't even want to find out the result of what happened. So that's an approach which I follow. So I'm not really the correct person to answer this question.
Okay, sir. Mr. Himanshu, your question has already been answered, so I'll move on. And Manoharji, we'll give you the mic to ask the first question that you put. The second one I'll put to sir because we've already talked about section 340 CRPC. So the question that Mr. Manohar wants to put is whether amendment is required in section 340 of CRPC to make it compulsory for the honorable judges hearing and conducting trial for years and ultimately acquitting the accused to pass serious orders against complainant and impose heavy costs. This may probably reduce false cases. What are your views?
See, already 340 is a duty, but yes, it can be emphasized, it can be made stronger, it can be made more emphatic. The duty could be more pronounced. You could have some explanation. You could have some, some kind of a mandate in section 340, or it could be activated. I really will have to examine this question to be able to answer it and do justice to it. But definitely this could be a reform area. 340 could be a reform area.
Right, sir. I'll give mic to Mr. Amar Shankar now for his question.
Sir, good evening, sir. Sir, like I have a question, like in the bail matters, when we are applying for the bail, there is a close nexus between judges, IO and the PP. They are in the one team and the defense counsel on the another team. So what to do in these cases? And particularly, sir, like one more thing, like if in the bail matters, particularly if you don't bribe that IO, then you won't get the bail. Well, I have witnessed it many times.
I will not agree with you. I'm again not the correct person to answer this question. But you know, okay, assuming what you are saying is correct, hypothetically assuming with your experience, you have made a statement. The only way is to fight your way to the higher forum, or you know, maybe make a complaint to the higher judges at an administrative level, or take it up with the bar president, take it up with the bar. So these are some of the strategies or some of the things that you can do. I have faith in the system. I trust the system. I feel that everybody is doing his job. There would be aberrations. I'm not living in a utopian world. I'm not saying that everything is hunky-dory, everything is 100% fine. But I would believe 90%, 80% things are fine. Now, whatever vices and malpractices you are talking about, take it up with the bar, take it up with the high court judges, take it up with the district level judges. So, and fight your way. That's the only way we lawyers are taught. Fight by the rule of law. You
Yes,
can't
sir.
law
Indeed.
into your own hands. Huh?
Yes, sir.
Fight through the rule of law. Fight with your voice.
Yes, sir. Yes, sir. Indeed, like the things I have witnessed, that was I am sharing, because I have seen that these people are in one team and the defense counsel is on another team, and it's very difficult to get a bail on even on a very petty offenses.
That is why, my good friend, we have a judicial hierarchy. That is why you have the appellate courts and the higher courts. And so you have to fight your way into the system. That's my way. That's the only way which I know. Fight for justice. Fight with the rule of law. That's the only way I have understood in 3 decades. And be objective. Be objective about after losing a case also.
Yes, sir. Thank you, sir.
Next time. Try and do better the next time. These are the only ways I have thought, I have understood.
Yes, sir. Thank you.
Right,
Thank
sir.
you, sir.
Thank you, Amarji. And sir, with this, I think we've already consumed the stipulated time that we have had for today. And with that, I would also thank you for coming up for the webinar. You have such a heavy desk. We all know that. And it was an honor sharing the screen with you, sir. The kind of clarity of thought that you have and the kind of energy that you have and the passion that you have in, delivering what you're delivering, it actually moves all of us. I think everybody would second that. And before we go, I would ask for your 2 cents for the junior counsels who are sitting right here. We have a footfall of like 300 people right now, and they are waiting for your last words. And sir, also, abhi mere ko ek comment aaya which was very interesting. I would, just float it out loud. Somebody just suggested from my team only. They suggested कि sir ने जो book का overview बताया, we could actually have a short series on that. So I am just floating it out loud, and I give the floor to you now.
I'm sure there must be a soft. You want a soft copy of the book?
Sir, a short series on the
Series.
topics that you have.
Series means some OTT kind of a.
No. He wants episodes of your lecture on
Yeah,
chapter wise. That's what he meant.
I'm always open, you know, I normally never say no to speaking assignments because that's a way of payback to the society. So, you know, unless my desk is impossible professionally, I normally don't say no.
Amazing, sir.
Yeah.
Sir,
And for the young lawyers, I can
Yeah.
only say, you are the future of the bar. You know, you are the future of the bar and your time will come. Apna time aayega. Just work hard, keep working hard. Whatever comes on the table, do it to the best of your ability. Don't say no to any case. Please put in the same hard work in every case, whether it is free or for a fee. Whether the fee is big or small, please treat every case with equal importance. Please build up a quantum practice. Please don't chase money. Money will come. Money will come. So these are some of the things, you know, follow your passion, try and do something new, keep evolving, keep reinventing yourself. So these are, and there's no substitute for hard work. There is, for me, it is not Harvard, it is hard work. So, you know, this is, and no court is small, no court is big, only the fans and the air conditioners change. Ultimately, it is all the same. When you appear before a magistrate, you have a judge, you have an opponent. When you appear before the Chief Justice of India, you have a judge, you have an opponent, you are there, you have the facts and you have the law. So treat all courts as the same. There is nothing called small court, big court, high court, this court, that court. Enjoy your work. Apna time aayega. As simple as that.
right, sir. Thank you so much, sir. It was a pleasure. It was an honor, and it was so much fun. आप comments देख ही रहे होगे, and you know, everybody is just you know, exploding.
Thank you.
So thank you so much, sir. We'll
Thank you. Thank
try
you.
to disturb you again very soon for another
No,
session.
my pleasure. Thank you very much. And you know, it was wonderful to be there on this platform. And thank you so much. Thank you. Thank you.
Thank you, sir. And thank
Thank
you
you,
to
sir. Thank you,
everybody
Raghav.
who
And thank
joined.
everybody else too, sir.
Everybody who joined and for their energy, and thank you for all the organizers, Saurabh sir, Shikhar sir, thank you so much, and we'll see you all soon for another session. Thank you. Good night.
Thank you. Good evening, everyone. Bye.